So yes, today we take up our last topic. Most of the rest of the portion of the syllabus have been assigned, have been covered. So if you guys have any confusion with regard to the portion that have been covered so far, even when I'm not teaching, feel free to write to me. And after the completion of this topic, I will hand it over to sir and he will take the remaining classes. So the last topic that we are going to take today is the Registration Act of 1908. So, which has been amended in 2001 with respect to certain with respect to 53A of Transfer of Property Act. Certain changes have been made, and I will share the amendment with you guys. But let's start with the basics here. Not everything will be required for us. Most of it can be skipped. I mean, I'll focus only on one section here, that is section 17, and certain other related, sections like section 49, etc. Effect of non-registration of documents required to be registered. So this document, this particular act requires that certain documents, certain instruments are registered. Okay, registration has a certain purpose and it has a certain effect. Okay, so hence section 17 of this particular act, which deals with registerable documents, says that certain documents have to be compulsorily registered. Okay, with regard to certain others, okay, it is optional. It is up to you whether you want to register or not. So that is under section 18 of the act. Okay, now in the beginning you will see that it talks about various different offices there. Okay, section 3 talks about Inspector General of Registration, then 5 talks about districts and sub-districts, registrars and sub-registrars. So registration happens in the office of sub-registrar. Okay, but if you have certain grievances, so if, for example, if it takes too long and if you have grievances of such sort, then you can go to the registrar's office. So this is basic. You guys can always go through it. So the most important portion that we are going to deal with is section 17 of the act, which deals with registration when compulsory. Okay, so the act is the Registration Act 1908. Okay, and the act is essentially under this particular section, that is section 17, talks about certain documents which need to be registered. Okay, compulsorily registered. So you have to register that. Okay, if you do not, then it has certain effects. So why register? So remember this in mind. Just because you register a particular document, it does not in itself confer you any title to any property. No, it doesn't. It's merely a proof of certain not the transaction, but stipulations related to transaction. So it's essentially to prevent fraud. Okay, so whatever is in the document will be considered to have been to have been the case. Okay, so it's verifiable. Okay, so registration essentially verifies the content of the document. Okay, so it avoids fraud. So it is in a sense a notice to the world that a document has been executed as well. Okay, however, do not assume that registration in itself will lead to the creation of title. No, it doesn't. Okay, for that you have to fulfill the other requirements of relevant laws. So for example, if it is under a particular provision of the Transfer of Property Act, all those other requirements as is laid down there have to be fulfilled as well. So registration in itself does not create title. Okay, so these are the three important reasons. Firstly, to avoid prevent fraud. Secondly, it's a notice given to the the world that a document has been executed, and and it doesn't work more than that. It's merely for these purposes, and not for the, it does not create title. Okay. So as I said earlier, section 17 deals with compulsory registration. Okay. It basically tells you what are the documents that have to be compulsorily registered. Okay. So yes, uh, uh, so why compulsorily register? Because from the registered document you can find out the stipulations. Okay, so from that you can find out the intention of the parties with respect to the document concerned. Okay, so let's look at section 17 of the Act. So section 17 talks about documents of which registration is compulsory. It's a very long section. The whole thing I don't intend to read out, but let's read out the relevant portions. Okay, it says under subsection 1, the following documents shall be registered if the property to which they relate is situated in a district in which, if they have been executed on or after the date on which this Act or the Indian Registration Act 1866 or the Indian Registration Act. Anyway, so you have to, following are the documents that you have to register. So what are those? First is instruments of gifts of immovable property. So under 123 of the Transfer of Property Act, okay, that has to be compulsorily registered. Okay. B, other non-testamentary instruments. So if it is not a will, okay, will is not compulsorily registerable. So other non-testamentary instruments which purport to operate, okay, so in following cases, okay, which purport or operate to create, okay, create, you write, declare, assign, limit, or extinguish, okay, whether in present or in future, okay, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property. So any sort of transfer of the kind which has been described here, if it is value is 100 or upwards, then it has to be compulsorily registered. And yes, C says non-testamentary instruments which acknowledge the receipt or payment of any consideration on account of the creation, declaration, assignment, limitation, or extinction of any such right, title, or so again non-testamentary. And of course not just freehold but also leasehold. Okay, so leases of immovable property from year to year or for any term exceeding 1 year, or reserving a yearly rent. Okay, so if it is of this kind, then it has to be again compulsorily registerable. And then E says non-testamentary instruments transferring or assigning any decree or order of a court or any award when such decree or award purports or operates to create, declare, assign, limit, or extinguish, whether in the present or in future, any right, title, whether vested, contingent, or the value of 100 rupees upwards. So even if it is like non-testamentary instrument, okay, transferring or assigning any decree or order of a court, okay, even then, okay, the same, if it has the previous effects that we had discussed, create, declare, assign, limit, or extinguish, even in those cases it has to be registered if it is of the value rupees 100 or upwards. Okay, then finally it says that a proviso says, provided that the state governments may by order publish in the official gazette exempt from the operation of this subsection any lease executed in any district or part of a district, the terms granted for which do not exceed 5 years. So that's the subjective power which can be exercised in different states. So this is the general rule. Okay, so the exception that you have here is the testamentary instruments. Okay, so that is essentially will. So if it is will, then will is not compulsorily registerable. You can, however, get it registered, okay, but it is not compulsorily registerable. A gift is something that has to be registered. The value of it doesn't matter, but if it is of other kind, okay, so its value has to be rupees 100 or upwards. If that is the case, then it is compulsorily registerable. And it just doesn't apply to freehold, but also leases of immovable property from year to year, okay, or for any other term exceeding 1 year, or reserving yearly rent. If that is the case, okay, then it has to be compulsorily registered. Okay, so there are further other provisions we will look at when we need to look at them. Okay, so for now this is what has to be compulsorily registered. Okay, so what are the essential elements for the purpose of compulsory registration of a document under this portion? Okay, that is section 17(1) of the Registration Act. The first important factor is that the document is non-testamentary. That is, it is not a will, okay, and it must create, assign, declare, extinguish, or limit. Okay, this has to be the effect of the document. Okay, it could either be in the present or in the future. Okay, so yes, why did they have to say that? Because in case of gift, future property cannot be gifted. Okay, only the present property has to be gifted. So gift is again separate, it has to be compulsorily registered. But if it is not, then in such case, whether it is in present or in future, okay, any right, title, or interest, whether vested or contingent. Okay, so whatever it is, it could either be vested or contingent. Okay, and then the next important point is that it has to be of the value rupees 100 or upwards. Okay, relating to immovable property. It's not referring to movable property, but immovable property. So if all these conditions are met, okay, then it has to be compulsorily registerable, compulsorily registered under the said provision of the Act. So wills, as I said, is a testamentary instrument, so it need not be compulsorily registered. Okay, so section 17(1)(a) says instrument of gift of immovable property requires compulsory registration. Okay, so gift requires compulsory registration. It does not matter what the value is. So whatever may be the value of the gift or the immovable property, whatever it is, even if it is below 100, okay, it has to be compulsorily registered. Okay, with respect to other sorts of transfer, then it has to be of rupees 100 or upwards. Now we can look at what is a gift in section 123 of the Transfer of Property Act. Okay, so the Transfer of Property Act says gift defines gift thus. It says gift is the transfer of certain existing, okay, movable or immovable property made voluntarily without consideration. So it has to be of existing property, not future property. Okay, so it has to be some existing property, movable or immovable property, made voluntarily, okay, without consideration. That's the specialty of gift, without consideration. Well, the idea of hiba in Islamic law is again little different, because there is something called hiba bil iwaz, in which there is some kind of consideration. So we are not talking about hiba here. Okay, so yes, so voluntarily, it's something made voluntarily without consideration by one person called the donor to another person called the donee, and accepted by or on behalf of the donee. Okay, so when is acceptance to be made? The acceptance must be made during the lifetime of the donor while he is still capable of giving. Okay, so if the donee dies before acceptance, then after death you cannot accept it. The gift becomes void. Okay, so that's the general idea of gift as is defined in the Transfer of Property Act. Okay, so gift can only be of existing property, okay, not of future property. So there is, however, another section of this particular act that I was talking about that is also relevant for us here. That is the gift made on on deathbed, okay, applicable to Muhammadan. So there are certain savings, okay, of donations, donatio mortis causa and Muhammadan law. That becomes an exception here. So nothing in this chapter relates to gifts of movable property made in contemplation of death, or shall be deemed to affect the rule of Muhammadan law. So this becomes an exception. So if this is clear, let's look at what is the effect of Registration Act on this. Okay, so yes, section 123 of the transfer of property requires that, as we are concerned not about movable property but only movable property, it requires that gift of immovable property must be registered. Now read that with that of section 17(1)(a). That also says that it has to be registered. Okay, you do not have any other option here. Gift of immovable property must be registered. Then it operates from the date of the execution of the gift deed. Okay, so it does not operate from the date of registration, but it operates from the date of execution of the gift deed. Okay, when does the gift becomes enforceable? The gift become enforceable from the date of the signing of the gift deed. Okay, and registration of the gift deed would not by itself be an evidence of gift. Okay, one cannot say that okay, gift deed has been registered, that in itself cannot be a proof of the gift, because there are other requirements of the said section. Those have to be fulfilled, okay, as we have just discussed, and only then the deed will be complete. Or only then will we be sure that the gift has been in fact made. So registration is merely an evidence to prove that yes, all this is what has in fact happened. So that's the limited purpose for which registration is important. Okay, so yes, then we read section 129 of the TPA 1882. It says savings of donations, donatio mortis causa, as in Muhammadan law. So the said provision as that we have read does not apply to Muhammadan law. Okay, so in Muhammadan law there is a concept of concept like that of gift. It's not exactly gift, as it's of little different nature. Sometimes it overlaps, some other times it doesn't. So under Muhammadan law the concept of gift is known as hiba. Okay, so for Mohammedans, this is not a necessity. Okay, so registration is not compulsory. What is the reason? Because in gift, as is understood in the in the Mohammedan law, is more in the nature of an obligation. Okay, so more in the nature of an obligation than a transfer of title, as we understand. Okay. So what is it? So let's look at a case that will tell us. Okay, it's by the name Hafiza Bibi. It's by the name Hafiza Bibi and others versus Sheikh Farid. Okay, so this is a very important case. Okay, so it says that there are three essential elements of hiba. Okay, what are those? That there has to be a declaration of gift by the donor. Okay, declaration has to be there. Okay, acceptance of the gift by the donee. Okay, and then thirdly there is something called delivery of possession. Okay, so if these three elements are met, then hiba is complete. Okay, so the rules of Mohammedan law does not make writing essential for the validity of a gift. Okay, so oral gift could also be made. So the thing is that if it is oral gift, how do you register? Okay, so registration is not compulsory under. So as I said, it's more in the nature of an obligation, okay, than a transfer in itself. Hence, there is no compulsory registration under this particular portion, that is hiba. So the same happens if a Muslim makes a gift of immovable property to a Hindu. Okay, if it is by way of a written document, it need not be registered. So with respect to Muslims, this is the this is the exception that has been created. So yes, so I hope the first portion is this particular portion is clear. Uh, so remember this, in this particular case, why do we say that the document which has been registered is not proof of the title? Because the document merely says, okay, declares the intent of the parties, okay, it does not tell you about the entirety of the transaction, okay. So that's the portion that you essentially get registered, okay, that is the document. Okay, now what is a document? To understand what document is, we need to look at the definition of document given not under this act but under the General Clauses Act 1897. So section 316 of the General Clauses Act 1897 says a document shall include any matter written, okay, it could be written, expressed or described, okay, upon any substance by means of letters, figures, marks, okay, or by more than one of these means which is intended to be used or which may be used for the purpose of recording a matter. So documents essentially record a particular matter, okay. So and then section 3 of the Indian Evidence Act 1872 also defines a document as a document shall mean any matter expressed or prescribed upon any substance by means of letters, marks, okay, intended to be used for the purpose of recording the matter. So both the definition says that documents essentially, if apart from the other aspects of the definition, says that it essentially records the matter. So once the document is registered, it's basically an officially verifiable record of the matter. That's the limited purpose with which registration is done, okay. So in all these different kinds of transfers, so it could be a mortgage, it could be a sale, or it could be a lease, if it is of the value rupees 100 or above, okay, then it has to be compulsorily registered, okay. But remember, it has to have the nature that we have just discussed, okay. So what are those natures? Those are very essential, okay. So it must create, assign, declare, extinguish, or limit. So all these have the effect of creating some right, title, or interest, okay. That has to happen. Without that requirement being fulfilled, there is no necessity of compulsory registration. So it has, those are the requirements. So there are some kind of transactions that happen quite often but are not registerable, okay. So that is very important, okay. So it has to happen through, for example, a sale deed, okay. So sale deed has to be there, and only then will that document be registered. Now sale by agreement, okay. So what happens there? There is no sale that's happening. It's merely an agreement that a sale deed will be completed in future, okay, but it hasn't happened now. So that document is not compulsorily registerable, okay. So that document, okay, will not be proof of transfer of any property. So it will not even be evidence to prove that there has been a transfer of property, okay. So this is something very important for us to keep in mind, okay. Only of the kind that we discussed, those are the documents which are compulsorily registerable, and if registered, those documents will basically give us enough evidence, proof to say that certain transaction has in fact happened. But that's not the proof of the transaction in itself, because other conditions are also to be fulfilled as laid down under a particular provision of the law. So in this regard, a very important case that you guys need to know is by the name Suraj Lamps and Industries Private Limited versus State of Haryana. It's a 2012 Supreme Court judgment. It's important in the sense that in certain areas, especially in Delhi, where people do not directly transfer the property through sale deed, okay, there are many different reasons, okay, that stamp duty is very high and cost of registration is there, and there are so many other costs associated with transferring a property, and then the price of the property goes up. So to avoid having to deal with all that, people have come up with alternative ways. So there is a power of attorney act. Okay, under that you can give someone general power of attorney. Okay, now when you give someone general power of attorney, it used to be almost like selling like sale of a particular property. Okay, but it's not exactly the sale, so that's something the court dealt with. Okay, so what happens is that immovable property can be both legally as well as illegally transferred. So we are not concerned about legally. Okay, but so immovable property can be legally and lawfully transferred or conveyed only by a registered deed of conveyance. So whatever is the mode of conveyance, it has to be through it has to be registered. So that's the legal lawful way of transfer. Any other kind of transfer, okay, is not proper transfer. Okay, so as I told you, in these areas people had come up with certain alternatives. So how would they do that? So instead of transferring the property itself, they will first sale by agreement. Okay, so agreement to sell. Okay, so it just creates personal obligations, if you remember, between the seller and the buyer, isn't it? No, it's here they are not seller buyer, two parties to the agreement. Okay, so and then afterwards what they will do is they will create general powers of attorney sales. Okay, so through that almost all powers are given to the person in whose favor the general power of attorney is created, and ultimately to avoid any problems they transfer by will. Okay, now what if all these three things, okay, this general sale by agreement to sell, GPA, and transfer by will, if these documents are registered, will they amount to transfer of property as we understand, for example, when it is done through a sale deed? Are they equivalent? The court in this particular case held that they are not. Okay, so general sale by general power of attorney sales is not equivalent to that of sale through sale deed. Okay, they are not the same thing. So it will not create a property interest in you, so it will not give you title in a sense. So since they are no longer equal, it may create certain limitations on you, in the sense that you cannot sell the property further because you are not the owner of you do not have the title to the property, nor can you get, for example, some loan from the bank. You cannot do so. All you can do is probably GPA the property further. Okay, but prior to this particular judgment, there was a confusion about this matter. Okay, but after this judgment, it has been made clear that GPA sales, okay, are not not equivalent to sale deeds. Okay, so in these matters, okay, these are not compulsorily registerable. So even if it is registered, it is no proof of the fact that sale has in fact taken place. Okay, so so this rule, as we have just discussed, as I told you guys earlier, applies not just to freehold property but also leasehold property. As we had discussed earlier, the rule applies to not just freehold but also to leasehold property. So essentially in this particular case, what we learn is that GPA sale, GPA sale, or which is not really sale, it's basically a general power of attorney. Okay, it neither conveys any title nor does it create any sort of interest in the immovable property. So it's not compulsorily registerable, and the same shall not be proof of any conveyance having taken place. So that's the rule that has been laid down. Another important case that we can look at is by the name Hansia versus Vaktavarmal. Okay, that's an old case, 1958. Okay, so the question is how for a non-registered document, okay, which is compulsorily registerable, as under section 17 of the Registration Act, can be used in a proceeding. So let's look at effect of non-registration of a document which is compulsorily registerable under section 17 of this particular act, and that is essentially something that you will find in section 49 of the Registration Act. So let's look at what section 49 of the Registration Act talks about. Section 49 says effect of non-registration of documents required to be registered. So it says no document required by section 17 or any provision of the Transfer of Property Act, okay, to be registered shall affect any immovable property comprised therein. So if it is not transferred, okay, if it is not registered, then it will not affect the immovable property comprised. So if you have made, for example, the transfer the property through sale, but registration is a important requirement. If that is not done, then the sale has not happened, so conveyance has not happened, okay. So it shall not confer any power, okay, to adopt, okay, or be received as evidence of any transaction affecting such property or conferring such property unless it has been registered. So it cannot even be taken as an evidence, okay, of any transaction affecting such property. So because it's not registered, it has no evidentiary value. That's essentially what is being said about it, okay. With respect to the transfer that we are concerned about, it's no proof of transfer. Okay, that's what has been said, okay. So in this particular case, it was held that a suit of redemption based on unregistered mortgage deed is bound to fall. So what does it mean? So for example, I'm the mortgager and someone is the mortgagee, okay. So mortgage, if it is of value 100 or above, as we have discussed, if all those requirements are fulfilled, then it has to be compulsorily registered, okay. So if it has not been, then in a case of suit of redemption by the mortgager, it will fall, okay. So with respect to that, why would it fall? Why would it fail? The simple reason is that the same has to be compulsorily registered. If it has not registered, then we cannot assume that even a mortgage has in fact taken place, okay. So it says that much because the purpose of the mortgage deed is to prove the mortgage, okay. So how do you prove the mortgage if the document that proves the mortgage is not registered, and registration is a compulsory requirement? So a suit of redemption will fail, but a suit of possession will be completely different, okay. So that is going to be something else. But with respect to this, a suit of a suit of redemption based on an in case of an unregistered mortgage will fail, as has been held in this particular case. So yes, it says the proviso to section 49 of the Registration Act 1908 cannot be relied upon for availing any benefit in suit of redemption. Collateral purpose, as we discussed, okay, if there are for any other collateral purpose the same, it's a different matter, okay. So as I said, in case of possession, suit related to possession, that will be completely different matter. But with respect to redemption in itself, okay, yes, it is of not much use, as has been held in this particular case. Then we will take 3-4 more cases, and that should suffice for this topic. So another important case is by the name Tegh Bahadur Bhujil versus Devi Singh Bhujil, year 1966. So the question is related to family arrangement, okay. So what about family arrangement, okay, and it could have the said effect as we discussed, okay, of creating interests, okay, title, etc. So where a family arrangement has been brought about by a document in writing, so basically who gets what, etc., etc., by virtue of a document in writing with the purpose of using that writing as a proof of what the family has arranged for. So essentially all the requirements of the said section that we discussed are met here. Okay, so if it is of the value 100 and above, of course in this particular case it is of the value 100 and above, then such a document has to be compulsorily registered. Okay, because it tells who gets what. Okay, and it is of the value 100 and above. Okay, and it has the effect of creating title, rights, interests, etc. Then such a document, if it is written, has to be which is in writing, has to be compulsorily registered. But if it is a merely purely family mutual family arrangement, okay, that okay, it does not create new title, merely within the family you decide something. Okay, so it does not have the effect of for example limiting or extinguishing someone's right. Okay, if it is something of that sort, but merely temporary arrangement, then that will not be compulsorily registered, because it's all about purely like mutual family understanding. So in a case by the name Ghulam Ahmad versus Ghulam Qadir, AIR 1968, it was held that when the agreement is purely mutual or a family one for the enjoyment of property without limiting or extinguishing the right, okay, if it has the effect of limiting and extinguishing the right, then again the section becomes applicable. But if it is not, then it may not be registered. You can still get it registered, but it is not compulsorily registerable. Then we will just take two more cases. Next one is by the name K. Raghunandan and others versus Ali Hussein Sabir and others, AIR 2008. So here we are concerned with section 72(6) of the Registration Act, which states that nothing in clause B, C of section 17(1) shall apply to any decree or order of court except a decree or order expressed to be made on compromise or compromising immovable property. Okay, so let's look at section 17 again. So section 17 BC talks about non-testamentary instruments, etc., etc. Okay, so fine. Okay, let's look at this one, 17(2)(6). 17(2)(6) says any decree or order of a court except a decree or order expressed to be made on compromise and compromising immovable property other than that which is subject matter of suit or proceeding. So if it is a compromise with respect to immovable property, which is a subject matter of suit or proceeding, what is the effect of that? Okay, so this is a very interesting case. We have seen earlier that if there were certain effects of a decree or order of a court, okay, meeting the conditions that we had earlier discussed, then it is compulsorily registerable. So what was held in this particular case is that a decree or order of the court, including a decree or order expressed to be made on a compromise, okay, if it is based on a compromise between the parties, which declares pre-existing right, okay, does not by itself create new right. Okay, so that's the condition here that needs to be looked at. If the compromise was such that it changes the right, okay, the existing right, then that has to be compulsorily registered. So it said in this particular case that a decree or order of the court, including a decree or order expressed to be made on a compromise, okay, which declares the pre-existing right and does not by itself create a new right, title or interest in presentee in immovable property of value 100 and upwards, that does not require registration. But if it did, so if it was a compromise of the nature in which it did not merely declare pre-existing right, but it was like, okay, I give up this and you give up that, something of that sort, then that definitely creates new rights. Okay, so if the compromise is of that sort and if it is of the value ₹100 or upwards, that will be compulsorily registrable. But if it is merely a declaration of pre-existing right, okay, and it does not create any new right, then that is not compulsorily registerable. And the last case that we take is Meghmala versus G. Narasimha Reddy and others, 2010. Okay, so it's quite simple. Okay, what about an agreement to sell? Okay, agreement to sell. So it says that an agreement to sell is not a sale. There is no conveyance that happens. Okay, so it does not merely on itself. It does not in itself, okay, create any new title or interest in favor of the buyer. Okay, so if that is not the effect, then the same is not compulsorily registerable. So an agreement to sell does not create any right, title, or interest in favor of the intending buyer. So an agreement to sell does not fall within the mischief of 53A of Transfer of Property Act 1882 or section 17(1)A of Registration Act 1908, and hence an agreement to sell does not require registration. Now, why is this important? Because of an amendment that had happened in 2001. Okay, what is that amendment? Let's find out. Okay, so in the amendment to the act that had happened in 2001, in you go to the third section there. I will share this with you guys. Okay, it says amendment of section 17 in the section 17 of the Registration Act. Okay, it says after subsection 1, okay, the following subsections shall be inserted. So 1A was inserted to section 17 after section 17(1). Okay, what does it say? The documents containing contracts, okay, to transfer for consideration. So contracts to transfer for consideration any immovable property, okay, for the purpose of section 53A, okay, Transfer of Property Act, shall be registered if they have been executed on or after the commencement of the registration related amendment. Okay, and if such documents are not registered on or after such commencement, then they shall have no effect for the purpose of section 53A. Okay, so it's saying that documents that contain contracts to transfer for a consideration, even that has to be compulsorily registered, and if it is not, then it will have no effect. Then that is what has been said. Now the question is whether this applies to the case of agreement to sell. Okay, now this is where the equitable portion applies. Agreement to sell, okay, is not a it's not a transfer. Okay, so it does not in itself create any right, title, or interest in favor of the intending buyer. So it does not fulfill the requirements of section 17(1). Okay, A. So an agreement to sell does not fall within the mischief of 53A of the Transfer of Property Act. Hence, section 17(1)A, okay, of the Registration Act 1908, which was inserted by virtue of the amendment that we discussed. Okay, so it does not require a registration. Okay, so that's how it has been interpreted in this particular case called Meghmala versus G. Narasimha Reddy and others. But with respect to other aspects, the 53 is still applicable. Okay, but with respect to this, if it is an agreement to sell, because it does not fulfill the definitional criteria as has been put there, well, it does not apply. Okay, so that's essentially what the registration is all about. So to end this discussion, registration is essentially something that you have to do. Okay, there are certain purposes behind why it is to be done. Okay, the most important purpose is that so as to prevent fraud. Okay, that fraud should not happen, and secondly, that it is a notice to the world that a particular document has been executed. Okay, so yes, that's what the purpose of registration is all about. And the documents, okay, of the kind which is there in the definition provided in section 17, if it is of that kind, okay, which has the effect of creation of any title, okay, right or interest, whether invested or contingent, of the value rupees 100 or upwards, but it has to be related to immovable property, then it is compulsorily registerable. Then section 18 of the said act deals with documents of which registration is optional. So if you register it, then it will be a proof of, okay, what is there in the document, okay, nothing more, okay, nothing more than that. But these documents are not compulsorily registerable. So you guys can just go through it. So we can just quickly see what those documents are, and then we can end our discussion for today. It says instruments other than instruments of gifts and wills, okay, which purport to operate, to create, declare, assign, etc., whether present in future, right title interest, whether vested contingent of value less than 100. So if it is less than 100, you can choose to register it with respect to immovable property. Then instruments acknowledging the receipt or payment of any consideration on account of creation, declaration, assignment, limitation, or extinction of such right, title, interest. Leases of immovable property for any term not exceeding 1 year. So previously we have seen that exceeds 1 year. And leases exempted under section 17. And instruments transferring or assigning any decree or order of a court or any award when such decree or award purports or operates to create, etc., whether in present or in future, whether of value less than. So if it is more than 100, then it is compulsorily registerable, but if it is less than, then it is optional. Instruments other than wills, okay, which purport to operate, to create, declare, assign, etc. Fine. Then wills can also be registered, as I said, but it is optional, it is not compulsory. And finally, for all documents not required by section 17 to be registered can be registered, but these are optional. So that's it. That's what this particular act is essentially about, and this is the part portion that is relevant for us. The rest of it you guys can understand on your own. So thank you. That's the end of the discussion relating to registration. If you guys have any confusions, clarifications, if you found any flaw in the way I was trying to explain, you guys can always point that out below in the comment section. Thank you, and I'll consider that.